607. Good evening. Can you confirm if you see a screen? Medical negligence lecture 2. Can you see that? You're not seeing that? Oh no. What's happening? Let's see. It's okay. Can you see now? Right. So very good evening to all of you. So last week when we had our very introductory lecture to medical negligence, we sought to explore what medical negligence actually entails and historically how accountability has been visited upon those who, for one reason or the other, uh, by their conduct or mission, occasion injury to others in the course of seeking healthcare or medical treatments. So we look at the various aspects, and we also sought to understand the policy goals which underpin this particular area of the law. Of course, it's not cast in stone, but it's still evolving in the sense that it is a debate which is not settled, which has not been settled, and is not going to be settled today or tomorrow. It will be ongoing because of the peculiar nature of human health, the human person. Human health, human person, the knowledge, the skill, the science, which are applied in trying to help the human person to overcome disease or illness, overcome pain, avoid premature death, and so on, and enhance general well-being in life, keeps evolving. And as knowledge, the science keeps evolving, it also has implications on what society, for that matter, the legal system, the law, is seeking to achieve when it comes to holding healthcare professionals accountable. So those are the matters we explored last week. So tonight we are starting part one of a two-part thematic area in this course. That is the theories of liability, causation and damages due to healthcare breach and causation. So what we are doing, we are going to have a comprehensive overview of this area of the law, and I'll call it like the general part. And in our subsequent class, we will try and contextualize it into some specific instances, as it were. So medical negligence, as we have seen, also refer to medical malpractice or clinical negligence, as the case may be, arises when a healthcare professional breaches a duty of care owed to a patient, causing injury or harm. So the question is, what are some of the theoretical paradigms which account for apportionment or allocation of liability as far as this particular area is concerned? So traditionally, we have negligence, which is mainly a fault-based liability. Fault-based liability in the sense that the law is holding you accountable because in view of the law, you have done something which is wrong. You are at fault, and that is why you are being made to bear liability. So that is a fault-based liability, and typically in the area of a tort of negligence, that is how it is. But before, when the law says that you are at fault, and for that matter, liability kicks in, the law understands the fault is talking about here in a particular sense. Is not in the normal sense of fault. No. So that within this particular area, when we say that someone is liable for negligence, for example, certain elements must be present. And what are these core elements? So first, there must be a duty of care. The person making the complaint or the person seeking a remedy against the other, that we call like the plaintiff or the claimant or the victim, as it were, must demonstrate that the other person, the other party, that is a defendant, against whom he is seeking liability, owed him or her a duty of care. That is to say that in the eyes of the law, the defendant, in this particular case, the healthcare professional, was under obligation to have conducted himself or herself in a way which would not occasion harm or injury to the patient. So, in the context of medical law, this is or medical setting, this is not so much of a problem because of the existence of the doctor-patient relationship. Once the doctor-patient relationship exists, then there's very little or no room for debate as whether the healthcare professional, for example, owed a duty of care towards the patient. And of course, the story of how a duty of care actually exists goes back to a well-known case, or what lawyers will call the celebrated case or the cause célèbre, the case of Donoghue against Stevenson. A very interesting case in the sense that before Donoghue and Stevenson was decided in 1932, the position of the law, that is the common law, has been that there was no general framework for holding people as owing a duty of care. And that duty of care was actually piecemeal. Piecemeal in the sense that there were no defined scenarios in which the law had actually recognized that someone owed a duty of care to another. For example, when it came to maybe like the road users and other things. So therefore, where you had suffered an injury, but you could not bring yourself within the existing categories in which the law says that a duty of care is owed to you, then you could not seek a remedy in negligence. So that is how bad it was. Meaning that once you suffered an injury, you should be probably praying in your head, maybe saying you are Hail Mary if you're a Catholic, that you'll be able to get your case subsumed or put under one of the defined categories or scenarios which the law says that a duty of care is owed. And that was really a tall order and oftentimes resulted in an injustice. The whole thing changed when in Donegal and Stevenson, the law laws through the creative thinking of Lord Atkin, we made the observation that the law must have like a broader perspective regarding when a duty of care can be said to exist. So he sought to create the generalized situation that if we have, let's say, A and B, and A knows that if he is behaving in one way or the other, or he's failing to behave in one way or the other, and the way and manner he behaves or chooses not to behave is going to impact negatively on, let's say, B, then in that case, the law will recognize existence of duty of care between A and B, that A is under obligation in law to exercise requisite care so as not to occasion harm or other forms of injury to B when he is acting or when he's failing to act. So that is what is popularly known as the neighborhood principle, the neighbor principle. And therefore, where we have that proximate relationship, a proximate relationship, someone is so close to you, not only geographically, but relation-wise, that if you don't have the person in contemplation when you are acting, and the person is likely to suffer injury or damage, then you owe the person a duty of care. Of course, that has been elaborated on in so many cases, especially when in a very novel situation, the court has never really made any determination as to whether duty of care exists. And sometimes we have like a policy issues at stake as to whether public policy will favor extension of a duty of care in certain areas, or for some other good policy reasons, duty of care should not be recognized to be existing. So you look at the case of the Caparo, Dickman, and so on. Those have been developed over there. But as I indicated, the basic requirement for fault-based liability in negligence, there should be a duty of care. And for medical contests, because of the distance of the doctor-patient relationship, it is pretty straightforward for us to identify or recognize existence of a duty of care. Let me see if I can make this thing a little bit bigger for you. Okay. Can you see the screen? Is it a bit, can you see the font size? Or small? Okay. Anyway, you can read it later. Let me make it this probably, okay. Yeah, so once you have established that a duty of care existed, you must go to the next level. You must prove that the relevant healthcare professional, by the way or the manner that he behaved on the occasion in question, that amounted to a breach of duty of care. That is to say that a failure to uphold the duty of care. Now, in that respect, the law will have to identify the standard of care, like the measuring rod. Just like we set examination question for you, we have a marking scheme which we use to say that this is what was expected of the student. And if the student did not do that, then the student has performed relatively satisfactory as we expect. and so on and so forth. So the same vein, if you make a determination that the healthcare professional owed the patient a duty of care, now before you can make a judgment as whether the healthcare professional breached the duty of care, you must have a baseline. You must have like a measuring rod, so to speak. And that is what we call the standard of care. So the standard of care expected of a reasonably competent practitioner in similar circumstances will be used to determine whether the breach of duty of care. And we mentioned the case of a Bolam against the Federal Hospital Management Committee, if you remember, where we said that going back to 1957, of course, the case which started from the Scottish, from Scotland, eventually made its way into the English law. Their lordships made the point that, well, using the direction which Justice McNair had given to the jury, that if what the particular doctor did when he was doing the electroconvulsive therapy, if of course, he did not apply restraint, and the patient actually, when the electrical distance was introduced to his body, he jacked off and then got injured. So there was the issue: would a reasonable medical doctor placed in the shoes of this particular doctor have conducted this procedure without, let's say, that applying restraint to the patient? Well, and McNair said that if a reasonable body of medical professionals will say that they will have done the same as the this defendant doctor did, that's the doctor who was working for the Federal Hospital Management Committee, then no fault has been made. He has not done anything wrong. He cannot be held liable for whatever injury that the patient might have experienced. And that was the dissatisfaction which this law actually faced for a long period of time, that if in the course of a trial, a healthcare professional could get a reasonable number of similar professionals to come and testify under oath, that in their experience, when cases of this sort, for example, come up, they go about it in the same way, then this defendant healthcare professional has not done anything wrong and cannot be held liable. Of course, you will notice how in the course of time, after about 5 decades, that approach of the law has become less and less popular. Now, when you have succeeded in showing that there was a breach of duty of care, that is still not the end of the story. You must also establish a nexus. You must establish a causal link between the injury or the harm that you are complaining of and the supposed breach of duty of care by the healthcare professional. In other words, you must be able to establish that the injury that you are suffering or the harm that you have suffered was as a result of the breach of duty of care, the wrongdoing by the healthcare professional. So causation, very important. And in that respect, we talk about two aspects. We have what we call the factual dimension of causation and then the legal dimension of causation. So factual causation uses what we call the Bradford test. You see cases like the Barnett against the Chelsea and Kensington Hospital Management Committee. I think there's a book, a brief of cases. I think I shared with you last semester, but if you don't have Aliza McLean brief of cases on the medical law, I will share that with you. And most of the cases that I mentioned, if you are not a lawyer or law student, you want to go and read the full judgment, you have like some reasonable brief. But if you want to bring then you download the full case and then you read the full case. But the factual causation, you are saying that but for, in other words, but for what the healthcare professional did, you wouldn't have experienced what you're complaining of. So that is the factual causation. Then we also have the legal causation, which asks whether the harm was a foreseeable result. In other words, yes, the healthcare professional has breached a duty of care, but the question is, the particular harm, the particular injury, which you are complaining of, was it foreseeable? In other words, in the usual scheme of things, could it have been anticipated that if the healthcare professional, for example, did not do his work well, this type or this head of damage or loss, will it have been occasioned? Will it have actually come up? So that is the what do you call it, the legal causation. So we look at the case of a rule against the Ministry of Health. Yeah, so then again, we come to the loss. You must have actually, of course, they go together. You must have actually suffered actual harm. If you've not suffered the actual harm, you can't get any remedy. Negligence is not just for giving into your fantasy or some imaginary expectation. Is situated in realities, like what you've actually experienced. Unlike a trespass, like a battery, assault and battery, where oftentimes you don't need to actually have suffered any particular injury, but all that suffice is that unpermitted contact was made to your person, or you're put into the anxiety that unpermitted contact was going to be made with your person. I mean, that will suffice for trespass to the person. But if we are talking about negligence, you must actually show that you suffered some injury. And in that respect, you need expert evidence. So there'll be expert scrutiny regarding cause and breach. The damage, does it actually emanate from the breach? So look at the case of the Bolitho against the city and Hackney, but we come back to some of these later. So as we have indicated in terms like the illustrative cases, we talk about Bolam against the Foreign Hospital Management Committee. We've talked about it severally. And what is noted for is that it established the standard of care based on a responsible body of medical opinion. That is to say that if a responsible body of medical opinion says that they have done what the defendant healthcare professional did, then there has been no breach of duty of care, and vice versa. Of course, that has been interpreted by scholars or academic commentators to be endorsement of what we know from medical ethics, medical paternalism. Medical paternalism, in the sense that it's like the healthcare professionals who are actually making a determination on their own as whether a particular conduct or omission by a healthcare professional it's acceptable or not acceptable. But later on, the courts, of course, became responsive to harsh criticism, which scholars are deployed in academic literature regarding the unacceptable aspect of the Bolam test, especially the medical paternalism and excessive difference, which the courts are said to have accorded to the medical profession, in contradistinction to how other professional negligence and other professionals are actually handled by the court. So the court became a bit responsive to those criticisms and actually toned down its posture in Bolitho against City and Hackney Health Authority, to the effect that the courts may reject medical opinions if they are illogical or indefensible. In other words, in Bolitho, the court was saying that it's not enough for you, the defendant healthcare professional, to have lined up other healthcare professionals to come and take an oath and say that if they find themselves in the shoes that wear, they have behaved in the same way. That is not enough. The court would actually scrutinize the basis upon which they are making those claims. And if the court makes an observation that their claims are flawed with illogicalities, is unreasonable, doesn't stand logical scrutiny, then the court will not actually give any weight to that. But Hawks and Co. Earlier on will have reminded us that even if a risk is small, a doctor's omission can be negligent if there is no proper basis for ignoring it. So here, so the principle, in law, there's something called the de minimis principle. De minimis principle, that's to say that the law is not about trifles. But then the human body is special. You don't play gamble with the human body. So you don't say that, oh, as for this one, it's nothing. If there is no proper basis for you ignoring a certain risk, however small it is, you could be negligent. And this is really important. Like, for example, those who do initial cancer diagnosis and things like that, they will find a tumor, or they will find certain things and say that, oh, we've done the pathological analysis and it's benign. I mean, let's forget about it. It's not causing any trouble. But if there is the slightest chance that even 10 years time or 20 years time to create a problem and you didn't do what was needed to be done, despite the fact that the risks are small, you could still be negligent, except where we have like a supporting justification for you not paying attention to that. So let's keep that in mind. Also, in White House against Jordan and the Maynard and West Midlands Regional Health Authority, the courts increasingly demonstrate judicial reluctance to substitute the court's view for legitimate but differing medical opinions. In other words, where you have competing, if you like, medical opinions, a group of doctors are saying that, well, they wouldn't have done this. Another group of doctors are saying that it is quite normal. That is how we have done it. It's not really the business of the court to simply prefer one to the other and reject the other just because of the lack of agreement. In terms of the standard of care too, later on, as we delve deep into these areas, cases like Wilsher against the Essex Area Health Authority will tell us that when it comes to the standard of care required of a healthcare professional, inexperience is no defense. If you're a junior staff, you must meet the standard of a competent person in that role. And there was a case, I think, I'll not mention the name of the hospital, when I was a lawyer. I mean, this happened about 4-5 years ago. When I was a lawyer, there's a hospital in Ashanti region. It's a Catholic hospital. And it is said that there was a a junior doctor who was actually on duty and under the medical regulation and policy, a junior doctor doing housemanship that's supposed to be supervised. Now there was supposed to be like a supervisor, but he was in charge of like the whole area in that facility. And this houseman was in a particular block. There was a woman who was actually it was in labor, and I think there had been what do you call it? Is it the inducing? Doctor, is it you induce? Is that how you call it? You said something to this expedite the good induction of labor. Yes, okay. Yeah. So I think there had been something like that, and they kept also checking what they call like is it the cervix size, or like the open, they have a certain measurement, isn't it? Uh, they call it what? Hello? Yes, good, good. So they kept checking that, and the woman was in deep pain and saying that yes, I want what do you call it, the CS, and then I think this doctor was ignoring and attempted to do the vagina delivery, but it became complicated. It was at the point of the complication that the senior doctor, the director, who was the supervisor, had to come in, and then how do you call it, the emergency, or CS or something like that. In which case, the baby had actually, did not make it. The baby had died. So it's even a matter which I'm sure Dr. Divine may know about it. It came to the Medical and Dental Council. I left practice, so I don't know what became of it, as whether they were able to deal with it or what. But if we look at it, I think the supervision was weak. The supervision was weak as far as the houseman or the junior doctor was concerned. The seniors should have provided a better supervision, and it's not the case. We should have turned what we actually witnessed. So that is why Wilsher against the Secretary Health Authority telling us that, well, inexperience is no defense. It's no defense at all. So if we look at the law of medical negligence, there's that challenge, of course, which is a policy matter in terms of holding the land, even, walking a tightrope between bringing healthcare professionals to accountability on one hand, and at the same time, not being ruthless in terms of holding them accountability, for the fear that it may trigger what we call overly defensive medical practice. What do you mean by this? That is to say that if we are not careful in how we mobilize and deploy the law of medical or clinical negligence, it may end up being counterproductive. As somebody said that you don't throw the baby and the what do you call the bathwater, isn't it? Yeah. You want to protect the health of patients. You want to safeguard human life. So if healthcare professionals don't behave well, they are held accountable. That is good. But then if we are also not careful and we overstretch things, healthcare professionals may become afraid when they are acting and may want to do their work in a way, a manner in which they will have ready defense should they be held accountable. So therefore, their focus is not on the well-being of the patient, but their focus becomes, if what I'm doing should go wrong, can I have a good defense? So that is the challenge. And that may also bring about, sometimes unnecessary or excessive diagnostic, investigations. Run this test, run this test, run this scan, do this, do this, do this, do this, do this, do this. And sometimes, as we saw last week, it may delay certain interventions, which can even, aggravate or escalate the condition of the patient. So those are some of the challenges that we have. And if you go to countries like the US, where we often talk about what they call a medical malpractice crisis of medical malpractice litigation, in which heavy compensation by way of damages are awarded, especially by jury, where they have like a jury trial and they will make heavy award. It can collapse the whole practice and hospitals. It makes it quite challenging. So courts typically rely on expert medical testimony, but as we have noted, it can reject it under Bolitho if it lacks a logical basis. So let's keep that in mind. Another point we will touch on with respect to liability is what we call the vicarious liability. So by vicarious liability, an employer is held responsible for employees' negligent acts committed in the course of their employment. In other words, if you're an employer, you engage an employee, and an employee should, for example, commit a wrong which qualifies as a tort in terms of, duty of care, breach of duty of care, resultant injury, and so on, then the consequence of that tortious behavior of that employee will be visited on the employer. Will be visited on the employer. Of course, you may ask why. The employee is more or less like your agent, so to speak. He's doing the work for you. You hire the employee, you determine his competence and skills level, and so on. Whatever the employee is doing, you are the direct beneficiary. You provide the work systems, right? The tools, the systems, and everything which the employee is using. So the law will hold you answerable for the consequences of the wrong doing of your employee. In medical contexts, so hospitals, clinics, or other healthcare institutions can be held liable for the staff negligence. So if a nurse does not behave well, phlebotomist does not behave well, radiologist does not behave well, the general practitioner does not behave well, the consultant, the surgeon, the dentist, the pharmacist, clinical psychologist, just name it, any of the health staff, if they do not behave properly and their wrongdoing can meet the threshold of negligence, then we will hold the hospital or the institution that they are working for Of course, and in any case, when it comes to practicalities of clinical negligence litigation, when you are suing, of course, in negligence especially, you have an eye on a financial award which will be made. So if a financial award is made and your defendant is a man of straw, in the sense that he or she doesn't have enough for you to execute the judgment against, you will not have achieved anything. So therefore, you want to find out this healthcare professional who was negligent and has occasioned injury to me or my client, was he working on his own or he was an employee of an institution? If he was an employee of an institution, then I'm going to sue the healthcare professional and then the institution together, so jointly and severally. So the healthcare professional, you sue the healthcare professional, then you also sue the institution. Because the institution, the advantage is that once you win, the institution definitely will have resources and you'll be able to get your money. So custody, for example, against Ministry of Health, the hospital was liable when the doctor's negligence worsened a patient's condition. And this, so many cases. You see the 37 case, University of Ghana Hospital, Kolebu, Komfanoche, Ashanti Good Health, Tamajina hospitals, all the medical negligence cases that we have in Ghana, for example. You notice that usually the plaintiff will target the health institution for which the defendant or the healthcare professional was working. And as I say, for good reason. And the theoretical, rationale for vicarious liability, among other things, will be that the institution benefits from the employee's work and therefore share responsibility for ensuring competent care. In any case, if you go to the hospital, the consultation fee and all that, it doesn't go directly into the pocket of the doctor, isn't it? Or the nurse, it goes into the coffers of the hospital. Then we also be dealing with what we call the res ipsa locuto. I didn't know a syllabus. We are supposed to have a whole topic on it, but we'll see if it is worth devoting a whole lecture to it. But res ipsa locuto simply means the thing speaks for itself. So Latin res rebus, a thing. So res ipsa locuto, that is the thing speaks for itself. And this applied when the nature of the injury strongly suggests negligence without needing specific evidence of breach. So, to give you an example, a patient went to hospital maybe for a surgery. After 1 month or 3 months, this patient is actually feeling severe discomfort. And part of his or her body is even swelling. There's serious inflammation going on somewhere. Then he goes to another facility. They said that no, we don't understand what is happening. So they run maybe a scan, imaging, or whatever you call it. And they said that we need to quickly open up. And they see, let's say, that the scissors or some other tools in the person. In that case, if the person still, he will be excused from proving all the various elements, breach of duty of care, all that. And we'll simply be saying that, well, in the normal scheme of things, scissors is not left in anybody who has undergone a procedure. And if seizures is actually found in me after the procedure came to do, then that in itself is evidence of negligence, unless you can provide an alternative explanation as to how seizures, for example, could have been left inside my bowels without anybody being guilty or liable of negligence. Therefore, to successfully plead res ipsa locuto, the plaintiff or the claimant must demonstrate that, one, the injury does not ordinarily occur after negligence. So the particular injury does not occur in the normal scheme of things unless somebody has been negligent. And two, that the defendant had exclusive control of the instrumentality that caused the harm. So the particular tools, particular instrument, or whatever is causing the harm should have been under the complete control of the defendant, the alleged tortfeasor. And three, the injury was not due to the plaintiff's own actions, that the plaintiff has not actually contributed or has not done anything to bring about the injury. So what it means is that we're saying that yes, the injury in the normal course of things will not occur unless somebody has been negligent. Two, the instrument or the means which caused the negligence was under the control of the tortfeasor, and that the person complaining has also not contributed or has not caused any the injury is complaining of. So there's a case which is often associated with the res ipsa locuto principle for the first time. So look at the case of Scott against the London and St. Catherine Doors Company Limited, a 19th century case. It's not directly, medical, case, but its principle applied to the situation that we'll be discussing, like retained surgical instruments, where negligence is self-evident. Another basis of liability, as far as medical malpractice is concerned, is also breach of contract. So patients may pursue breach of contract if a healthcare professional fails to fulfill specific promises or assurances about treatment outcomes. So and typically, you go to a facility. This may probably be a more when it comes to this body enhancing or body enhancement procedures. Those beauty enhancing or those kind of cosmetic procedures and so on. Somebody or facility will say that, okay, we can let you have a flat stomach and a good shape behind and those things, as people of this age actually encourage and admire. And so this is how much you're going to pay. You do all that. So here is a contract, isn't it? So they have actually given you a specific promise. So let's suppose that you do it and then you don't get the intended outcome. So that is a breach of contract. And that in itself can be a cause of action. You can sue on basis of that. Nevertheless, suing for breach of contract is less common than tort claims. Bringing action in negligence and battery and so on are relatively more common than people bringing actions for breach of contract in medical cases. And so how may a cause of action be sustained as far as breach of contract is concerned? So first, a contract exists between the doctor or the hospital. Of course, the vicarious liability also apply. And then the patient, typically in the private healthcare, that is more common. Like you go to like the private facilities and all that, you have the contract. And then the contract is breached. And then the breach causes harm. Then in that case, the principles for breach of contract, remoteness of damages, including the principle in Hadley and Basindel, clarified in the Victoria Newman and Landry, all become relevant. So the case of Take and Morris is an interesting case, and in that case, you notice that a couple went for a procedure, I think vasectomy, hysterectomy, so that they will not be able to get pregnant. And having done it after some time, what they call the ray, was it the ray? They have a term, the recarnation or something like that. The doctor, what is it? Yeah, so the wife became pregnant again, and they managed to let the child come forth, and they decided to sue and say that, but we came for a procedure and we paid. And the understanding was that we're going to do the procedure, and then even if we continue to have unprotected sexual intercourse and all that, there'll be no pregnancy. So why are we pregnant? And this and all that. So Take and Morris, very interesting case. But that case, the court made the point that unless there's a clear guarantee of outcome, contract for medical treatment and procedures will be interpreted as requiring the healthcare professional to exercise reasonable skill and care. And the court actually made the observation that, well, I think that was the Fitzmaurice, that if you look at the human, if you look at the human body, right, the human body cannot be reduced into mathematical precision, in the sense that even if you take two individuals, they're all human beings, but their bodily constitutions are different, and they will respond and react differently to various medical interventions. And that is why the court was very lenient regarding what the contractual obligations were. So the case of Take and Morris, you can download it and read. It's a very interesting case. So the jurisprudence or the trend of the case law, actually showed that, like, Scuraga, Powell, and then I and Misdale, and even like the Take and the Morris, all showed that before the court will be disposed to actually, please put your mic off. Yes, yes. Okay, all right, no problem. All right, so thank you. Yeah, so I was making the point that Take and Morris was, among other things, a case in which a couple sought to sue for breach of contract of medical treatment, and then the court was taking the view that unless there was an express term by the doctor or the healthcare professional or the facility that this outcome is guaranteed, it will not fail. Unless there's such an express term, the court will not insist that contract for medical treatment is meant to actually bring about a definite outcome. Now, that will only be entertained by the court, where upon construction of the contract, upon interpretation of the contract, it was so obvious that there had been insistence, there had been an assurance, there has been an explicit term by the healthcare professional or the facility for that matter that a particular outcome was assured and then there's going to occur. Yeah, so that was the point I was trying to make. So where no clear guarantee exists, the court will just use the usual reasonable skill and care. Doc, are we clear on that? Hello? All right, thank you. Another aspect of the basis of liability we also want to touch on is the informed consent. Failure to obtain informed consent can give rise to negligence if the patient suffers from a procedure they were not adequately informed about. So there is not only the actual act, but information, disclosure of information or withholding of information can also give rise to a cause of action in clinical negligence, as we saw in the case of Montgomery against Lancashire Health Board last semester. And the court reminded us that doctors must ensure patients are aware of material risks of proposed treatments and that there have been a paradigm shift from the paternalistic Bolam approach to a patient-centric model. That is to say that the patient that you are handling, you have to give him or her whatever material, relevant or important information, which would enable him or her to decide whether to embrace a proposed treatment or procedure or to reject same. And you know the story of a Montgomery against Lancashire. So, where the patient was not warned about the risks of if a cesarean session was not done, something could go wrong, and actually something went wrong. And then the patient was actually complaining that, why didn't you tell me for me to decide whether I will elect to have CS or have like a vaginal delivery, as you saw in the case. And of course, we had seen earlier on that in Sidaway, the court had sought to apply Bolam to disclosure of risks. So Sidaway had actually been pro-Bolam, saying that as whether a doctor can be blamed for not disclosing information to a patient or not is very much dependent upon what other doctors in the situation of this doctor will have done regarding such information. If they will say that in their clinical experience and expertise, they will not have considered it necessary to share this information with the patient, then this particular defendant doctor cannot be held liable for failure to disclose the information. Of course, Lord Scarman, will take an exception to that line of thinking. He was in the dissenting, minority, and many years later, Sidaway was the 1985 decision. Montgomery against Lancashire was 2015. So just about how many years? Is it 85 to? That's about 20 years, isn't it? Yeah. 20 years later, the dissenting minority view has become the position of the law. So for judges, if you are on a case, you don't have to be afraid to stick to your honest view of what you think the position of the law should be. Even if you are in the minority, if you are dissenting, many years posterity will come and see the wisdom in your position and probably embrace what you did. And that is what happened in the Cedar Way many years in the Montgomery against the like Nasher. Well, there's also strict liability. But strict liability in medical negligence is not common. It's quite rare. It will apply usually to defective products or drugs when it comes to product liability. We don't have consumer protection law in Ghana, but if you go to UK, they have the Consumer Protection Act, and the Consumer Protection Act creates strict liability for defective products. But I think the sense of that is reflected in the general principle of the common law when it comes to application of the Donegal and Stevenson principle or the duty of care to manufacturers' liability, that if you manufacture a product and you don't exercise requisite care, something goes wrong, then you will be held liable. But the thing about strict liability is that the plaintiff need not prove fault. All that you need to show is that the product was defective and caused harm. So you don't need to show that the manufacturer breached the duty of care. No. All that you need to show that there's something wrong with the product, there's something wrong with the drug, and it has caused harm to you. So once you're able to show that, yes, there's something wrong with the drug or the product, and then you have actually suffered harm, your case is made. But as I said, strict liability in that sense will be applicable to manufacturers or suppliers of, if you like, a product or medical equipment, rather than clinical decision by doctors and other healthcare professionals. So let me give you an example. Let's suppose that you are a manufacturer of a vaccine. Let's take vaccine, for example, and you have put in a particular active ingredient or which is not supposed to be in that type of vaccine because of the particular health condition or organism which is targeted by the vaccine. Now, in that case, there is something wrong with the vaccine. And it's not necessary for us to prove that you failed in your duty of care. That is why there's something wrong with the vaccine. Once there's something wrong with the vaccine and people have actually suffered injury as a result of that, you'll be held liable. What about criminal law? Can we have basis of liability from the point of view of criminal law? Well, in extreme cases, medical negligence can amount to gross negligence manslaughter. If you look at the case like R.M. Bateman, it creates that possibility. But of course, if you come to our Criminal Offences Act, when it comes to causing harm, you will notice that some exceptions have been created for those in the context of a clinical setting. But the possibility is there that under some situations, if you commit a medical malpractice, that could actually give rise to a cause of action in, like in criminal law, in this case, a criminal prosecution. But of course, where your action or mission deviates grossly from the standard of care that results in death, certainly, then you could face a criminal prosecution, even if not for murder, for manslaughter. So these are the various things we need to keep in mind in terms of the theoretical and legal foundations for liability in medical negligence or more practice. So having said these general principles of liability, we proceed straight away to take the duty of, take the medical negligence, look at the various components in a little bit more detail. So let's start with the duty of care. Duty of care. Existence and then the scope of duty of care. We have made the point that to successfully bring a case in medical negligence, you must first prove that the healthcare professional owed your duty of care. What is that? A duty of care usually arises when a healthcare provider agrees or expressly or impliedly to treat a patient. So once you accept the patient as your patient, a duty of care exists. You allow the patient to come to your facility. The patient take a card. You owe a duty of care. You've accepted the patient. So doctor-patient relation or healthcare professional-patient relation has come into being. And the duty of care is owed. And as we have noted, the court, building on from the case of Dondogo and Stevenson, and clarified subsequently in the Caparo Industries again, Dickman, would try and verify existence of duty of care using factors like proximity. Proximity, as we saw, like the neighbor principle. Can we say that the relationship between the healthcare professional and the patient is said that the healthcare professional, and for that matter, the facility, ought to have had the patient in mind in order to avoid causing harm when so acting or not acting. Then foreseeability. What the patient is complaining of and so on, having regard to the circumstances, was it foreseeable that if care was, for example, not exercised, something could go wrong? Was it foreseeable? And whether it is, let me give you an example. Let's suppose I go to a facility, right? They have the X-ray room. Usually the X-ray, they give indication that here is a exposure to radiation, so stay away. So let's say that the facility is big, and then the patient is probably about 80 meters from where the X-ray facility is. And let's suppose that the patient had not gone for X-ray, but was doing some other things. But maybe the patient is hypersensitive to radiation, however small or little it may be, and for that matter, get a certain condition and seeks to bring a case against the facility. In terms of duty of care, with respect to as whether the facility, for that matter, the healthcare professional in charge of the X-ray owed a duty of care to a person who is sitting about 80 meters from where the facility is. So the foreseeability will come in, the proximity point will come in. And again, is it fair, just, and reasonable to impose a duty? So the court will have regard to all these factors in trying to make a determination as whether a duty of care should be concluded to have actually existed between the parties. Provided some English context illustration. So go to UK, for example, we have what you call the National Health Service, and which started in 1948 after the Second World War, an attempt to provide some kind of like social welfare for the public when it comes to healthcare. So Pfizer Corporation against Ministry of Health reminds us that patients using the National Health Service facilities, that is the public facilities, generally have no contractual relationship with the Minister of Health or the National Health Service. So, of course, because of how their system is organized, so therefore, you cannot actually sue a particular GP or primary care facility or even like the secondary or tertiary facility under the NHS scheme for, let's say, a breach of contract, as it were. But they can rely on the tort of negligence for redress if harm occurs. So we've seen Take and Morris too, how private patients can have duality or the multiple causes of action in torts, the normal tort and then the contract, as we have seen. Again, cases like Watson, Watson against the British Boxing Board of Control illustrates gradual incremental development of the duty concept in novel settings. So the British Boxing Board, for example, was held to owe a duty of care to the boxer Michael Watson due to its construe and assumption of responsibility. So the point to note is that when it comes to duty of care, it's not cast in stone. The courts will look at the situation and be guided by the test which Caparo and Dickman has actually propounded. Of course, building on from Donegal and Stevenson, is there proximity, foreseeability? Is it fair, just, and reasonable to recognize existence of duty of care in that situation? So let us keep that in mind. Last year, I gave a detailed notes, and which is based upon work that I have done in my book. So I'll make a copy as available as part of the notes for you, and then a few critiques that I did with respect to some of these matters are there. So breach of duty. We have already talked about the fact that it's not enough to prove that a duty of care was owed. You must establish the second requirement. Was there a breach? And to establish a breach, we need to establish a standard of care. There should be a yardstick, which we are going to use to measure the acts or mission of the healthcare professional. And the standard is objective. That is the first one. We use the objective standard. And that is the standard of the reasonable, competent practitioner in the same position as the defendant healthcare practitioner. In other words, we find out how this healthcare professional behaves. Is it the same way in which a reasonable, competent practitioner, that is, someone who is equally qualified, like him, or certified, or hold himself as so qualified like him, will such a person have behaved in the way that this defendant healthcare professional behaved? And as we have noted, no allowance is made for inexperience. So a case of notarship and Western, Wilsher and Essex, that once you present yourself as a healthcare professional, we hold you to the same standard. And we don't say that this one is just a 1 year and so on. No. And that is why for lawyers, for example, there's something we call pupillage. And under our law, the etiquette and then the rules of the legal profession, if you're a lawyer and you're doing a pupillage, you have to do it under the supervision of a senior lawyer. And a senior lawyer, someone who is at least 7 years at the bar. Now, if you don't do that and you just practice anyhow on your own, and a litigant decide to sue you for professional negligence, it will be no argument for you to say that, oh, but I just left the law school less than 7 months. The same thing applies to the healthcare professionals. So junior staff are expected to seek guidance if needed. Again, with respect to the standard of care, timing and knowledge is important. And how is that important? That is to say that the standard of care is judged according to the knowledge at the time of the alleged negligence, not in hindsight. And there's that famous expression when Lord Denning, who, for example, made the point that one cannot view a 1947 incident with 1954 spectacles. And in that case, the particular accident under consideration in the court occurred in 1947. But the actual adjudication was 1954. And there had been developments, right? There have been developments in terms of improvement in how things are done. And there was that temptation as whether we should use the current standards, the current methodology or techniques to examine that which happened in the past. At the time that incident occurred, the current standard had not actually evolved, had not actually been adopted or emerged. And that is why His Lordship will make the point that it is wrong to view a 1947 incident with 1954 spectacles. In other words, we use knowledge in terms of competence, methodology, techniques, which existed at the time of the alleged negligence in making a determination as whether there had been a breach of duty of care or not. So, for example, let's take malaria treatment. I'm sure 20 years ago, the doctors, 20 years ago, what was like the typical malaria treatment that we had? Yes. Hello. All right, chloroquine, good. Is that chloroquine? Chloroquine, okay, so yeah, so good. Now, what is the current treatment now? Good. So it's a advanced refinement, isn't it, of the treatment? Good. So let's suppose that, I mean, just as an example, may not be a good example, but like, help us to understand that somebody is being tried for medical negligence, that the person administered the chloroquine, leading to the death or some serious complications. And let's suppose that now that we're doing the trial, and now we know that there's maybe a lot of articles in the medical literature or the journal showing how dangerous chloroquine is and how ineffective and so on, and other side effects. And now we have like this abudaquine and so on. So Lord Danning in Roe Against Minister of Health is warning us that it would be wrong for us to use the current treatment standard to judge the alleged breach which occurred at the time that chloroquine was the prevailing treatment. So that is the point to be remembered. Yeah, so we've also seen how originally the Bolam test was the prevailing approach. McNair J, for example, said that a doctor is not guilty of negligence if he has acted in accordance with the practice accepted as proper by a responsible body of medical men skilled in that particular act. So that is how the standard of care was defined. And that is why you talk about the fact that it was more a question of like, if you like, the quantity. If you got a certain number of doctors who are sworn an oath, then you come and say that, yes, if I was in the situation that this defendant doctor was, that is how I would have gone about it. Then case closed. Then the doctor can be left off the hook. And that's what you call like the Bolam test. And as we have noted, it gave significant difference to, it gave like excessive respect to medical professional opinion. But Bolitho, as we have seen, came to correct that, to say that a court can dismiss illogical or indefensible medical opinions, and that they must ensure that experts have weighed risks and benefits thoroughly. But the facts still remain, and this principle also applies to other areas of the law, that courts, yes, the general rule is that no court of law, no judge is bound by expert opinion or expert testimony. At the same time, there's also a principle that a court must not just reject an expert opinion without proper basis. Yes, you are not bound by what the expert is saying. However, if you are going to ignore it, you must assign reasons why the expert opinion or the expert testimony, for example, is not safe to rely upon. But if you don't give proper basis as to why you've rejected the expert testimony or report, in that case, on appeal, you are likely to reverse for that, especially if no party during the trial challenge the expert testimony or the report, as the case may be. I've looked at the Maynard, West, and then the Hawks and Co. So we're not a believer. The point. You've also made the point that when it comes to disclosure of risk, the same approach apply. Now we come to causation. Causation. So having established that there is a breach of duty of care, you must establish the factual causation. And that one we usually call it the Bradford test. The Bradford test, as we have seen from the case of Barnett against Chelsea and Kensington, the Hospital Management Committee, for example, that even if there is negligence, if the harm will have occurred anyway, liability fails. In other words, if you establish that there was a breach of duty of care, that is true. But then there's also evidence that despite the fact that there was a breach of duty of care, the harm that you are complaining of was going to happen anyway, or will have happened anyway. In that case, the harm you are complaining of is not because of the breach of the duty of care. So the Bradford test would not have been met. So that is the point. And if you read the case of Barnett, it's very interesting. We had some watchmen who were on a night shift, and after their shift in the morning, 3 people went to the emergency department of the hospital, and the hospital was run by the Chelsea and Kensington Hospital Management Committee. Now, they had visited the hospital as early as 4 a.m. because an intruder has struck one of them in the head with an iron bar. and they spoke to the nurse and told her that they have been vomiting since drinking tea at about 5 a.m. So look at it already. You have been hit. But then you're also saying that you had actually drank tea. And that is why you are vomiting. Now, the doctor who was at the emergency or the OPD, the casualty, did not see them, and he advised the nurse on phone that they should go home and call their own GP. Like that is their own doctors. Knowing that if you go to like the UK, depending upon where you live, they have like the surgery or the GP, the small, the primary hospitals there. You are registered, and if you need any healthcare, you go to your GP. Your GP will do all the things. If it's beyond the capacity of the practice and it has to go to like a higher hospital, then the GP will make like a referral. So that is how it's done over there. You don't just get up and go to big hospitals. Unlike Ghana, somebody has a headache, you can go to Kolebu, you can go to 37 and then the person will be attended to. No. That is why we have like unnecessary burden on the big hospitals. And instead of the, having the time and the space to deal with the very complicated cases, like relatively small cases which can be competently handled in smaller practices, they all make their way to the big facilities. So I think that those who are in charge of the health, in terms of efficient management and efficient allocation of resources, we need to calibrate some of these things. Do you have any government health regulator or ministry, Ghana Health Service in our class? Anybody? Oh, so none of our students are at the policy table. Okay. So one of the people who had actually gone to the hospital and then they had been asked to go home and that they should see their doctor, died about 5 hours later from arsenic poisoning. And the wife of the deceased sued the hospital for negligence. Now, the court took the view that the hospital was not liable. The reason being that even if they had admitted like the disease and the other people, there would have been little or no chance that treatment would have been administered to him to prevent his death. There's no doubt that the hospital had actually breached its standard of care. But what was the breach? A patient had come, instead of treating him or doing something, said he should go and see some other person. So that was like a breach. You accepted the patient. But then the court was saying that even if they had actually treated the patient, having regard to that which caused like the death, there's no way that they will have done any treatment to prevent that. And the person will have died anyway. So the proposition of law, which the court was reminding us, was that since the victim died from arsenic poisoning, and arsenic poisoning, the doctors will tell us is fatal, regardless of proper treatment. So we have died anyway. So the failure of the hospital or the doctor to attend to this patient, which of course was the breach of duty of care, did not suffice to have been the cause of the death. So the causation aspect was not made out. And this is what happens. Like the 37 case, I think my brother Akabuafu, I think decided it. That was it. The sometimes you'll be able to establish like the breach of duty of care and all that, but you may not be able to establish like the nexus, the cause. And here, we are talking about the factual cause. Are we saying that the Mr. Barnett would not have died but for the negligence of the hospital? And the court said no. Even if the hospital had actually treated him, he would have died anyway because of arsenic poisoning. Then the same thing applies to when it comes to informed consent. And the case I like all of you to read, the case of the Chester against Afsha, very interesting case, which is the application of like the Bradford test when it comes to informed choice or disclosure of information. So in Chester against the Afsha, there was a risk, a certain small amount of risk, which was not disclosed to the patient and then if you look at the literature, I think the risk was about 1% chance of the patient back pain getting worse. But the patient was not told. And later on, the patient was saying that if she had been told that there's 1% chance of the back neck pain getting worse, she would have probably not have either signed up for the treatment or something like that. But at least the court also attempted to show how the Bradford test may be applicable when it comes to disclosure of information. But the courts held the view that when it comes to informed consent or disclosure of information, the Bradford test, which applies in like those physical contexts, like whether something was done or not done, does not apply straightly as it were. But of course, you notice that in Montgomery against like Nashe, the court will now embrace the patient's informed consent, and so all these things will no longer will not be important consideration. Then we also have what we call the legal causation. Legal causation, that is the issue of remoteness. In other words, the particular harm or injury for which the patient is looking for compensation or damages, were those losses, those harms, those injuries foreseeable? In other words, could the tortfeasor have foreseen that if I did not exercise requisite care, then these type of injuries, these type of harms will actually be occasioned? So that like the remoteness. So I mean, students who have done tort, the case of the wagon mon number 1, although it's not directly about medical context, but the principles are relevant. And the wagon number 1 propounded that the harm for which you can recover damages or compensation should be a foreseeable type. And that is to say that if the particular harm or risk was not recognized as a risk at that time, then it's not foreseeable. You cannot get compensation. And that is why, remember what Lord Denning said, you can't look at the 1948, let's say that the incident with the spectacle of 1954. So was it foreseeable? We also have complex scenarios where we have multiple causes. Yes, let's say that there has been like a breach of duty of care. Yes, the patient has suffered something. But then while the patient has suffered, there are more than one cause. We have multiple causes. And the healthcare professional or the tortfeasor's breach of duty of care is just one of the various causes. So how do we ascertain liability? So if you look at the Wilsher against the Essex Area Health Authority, for example, we had multiple potential causes in that particular case, and that is why the court will say that for the plaintiff or the claimant to be successful, he must show that the breach by the healthcare professional was a material cause, or it made a material contribution. In other words, where you have multiple causes, before the defendant healthcare professional can be held liable, the role in terms of the breach of the duty of care by that healthcare professional should not be just insignificant within the set of causes responsible for the injury the person is complaining of. It should be a material, or should be one of the important causes, but not just insignificant. So that is the ratio of the Wilsher against the Essex Area Health Authority. We can apply Bolitho to so many scenarios. Now, if you look at the Greg against Scott, for example, you read the full judgment and you notice that the UK House of Lords did not recognize compensation for loss of chance unless the original chance was 50%. So there is what we call the novus actus intervenus, right? Novus actus intervenus, that is where there's been a breach of duty, and between the breach of the duty by the healthcare professional and the injury suffered, something interposes or something intervenes, something comes between, rendering the breach of the duty of care as not immediate and important cause. If the intervening event, the new event which has intervened, if it's sufficiently renders the preceding breach of duty of care insignificant, then the healthcare professional or the defendant cannot be held liable for the injury because of the novus actus intervenus, or because of the intervention of the third part, or like the event, external event. So let us keep that in mind. Well, in terms of the damages, that is the compensation, we have general and special damages or compensatory damages. So by general damages, we are referring to damages or losses which arise in the ordinary course of things, in the natural course of things, when there has been a breach of duty of care. So certainly, in a medical context, pain, suffering, loss of amenity. So loss of amenity here refers to certain bodily functions or certain enjoyment or uses that if it had not been for that particular injury you have been able to do, you will be given compensation for that. You'll be given award. Now, in terms of the money, general damages usually is lie within the discretion of the courts. And then there's what we call the statutory intelligence, where, in the past, you look at the law report to try and assemble negligence cases, find out loss of limb, how much was awarded in a particular case. Maybe loss of limb, 400,000. Amputation of leg, maybe 200,000, and so on. So once you look at the table of awards, it gives you a trend of how some courts have been, quantifying some of these losses, and that can serve as a guide to the court regarding the quantum of damages to be awarded. It's not binding, but then it gives you a certain sense. And I'm going to give you, there's, for example, one particular general damages. One particular, the case is still ongoing in various levels of appeal, so I'll not talk about it. Where you wanted to figure out how much money should be awarded, you look at the literature, you look at the McGregor and damages and all that, and then it will tell you that general damages for that type of cause of action is at large. At large means that it lies largely within the discretion of the court. But then, so from 0 to infinity, the court would like to know what amount is fair, to both parties, and that is why those data becomes useful. Then we also have special damages. So special damages are quantifiable financial losses. So losses that the plaintiff or the claimant can actually prove with evidence. So medical bills, you keep all your receipts. Lost wages, you can produce your pay slip, your letter of appointment and all that prior to the incident. So I can calculate how much you have lost. Or if you run a shop, probably you have your sales book and so on, ongoing care costs. So if you have losses as a result of the medical negligence, which you can prove by evidence, then once you can prove it, the court will allow you to recover. So for special damages, if you say that you're going to ask for special damages and you are not able to prove, the court will not award that to you. Then we also have what we call the exemplary or punitive damages. Sometimes you want to award damages or compensation as a means of punishing a certain reprehensible behavior. But in medical negligence, it's not common. Probably when it comes to defamation, right? When it comes to defamation and some other forms of trespass, that may be applicable. But for medical negligence, it's not really common. But of course, depending upon the circumstances, judges will take like a closer view of the behavior and the whole, incident. If, for example, the court can see some, major recklessness and malicious intent, then it may want to punish and indemnify such corporate involved. And of course, you also have the nominal damages, and where you can establish breach of duty of care, but no harm is actually proven. You may be giving nominal damage, but in medical negligence, that is not common. I mean, if like breach of, let's say, contracts, you can, let's say, establish that there's been a breach of contract, but then you cannot establish any actual injury or harm which you have suffered as a result of that breach. Then the court can award you nominal damages. So nominal damages is not substantial, as is, the term suggests. It's something symbolic. So just a token. Or maybe to say that Jiko Didi, if you remember those things in the universities. So how do we put money value to the damages? Well, damages aim to restore the patient as far as money can do so. We are trying to restore the patient to his condition before the injury, as far as money can do so. Of course, it's not perfect, but that is objective. And courts would often rely on medical experts, especially if it wants to get a sense of, so there's something you call like incapacity, okay? Incapacity. So, for example, your ability to function as a normal person, by what percentage is it reduced as a result of this negligence? So the doctor will say that, okay, because of this, you have a 40% incapacity, meaning that your ability to function and do on is reduced by 40% or 20% or 70%. So the higher the percentage, the more likely it will influence the quantum of the damages. And of course, in terms of the future, you may need actuarial experts to do some analysis and give a sense of what the future looks like in terms of your losses and your disadvantage by reason of this incident. But if you are a patient and you suffered negligence, you also have obligation to mitigate your losses by following advice for further treatment if reasonable. So you don't say that, well, for you, once there have been no negligence and you suffer some injury, you're not going to do anything about it. You're just going through the court process to get, whatever award you can get. Particularly so if there's evidence that something could be done to contain the injury from worsening or escalating. Yeah, so we've seen the relation between contract and tort already, so we'll not belabor it. So the key takeaway from our discussion tonight is that if we look at the jurisprudence or the case law, there have been a long journey from paternalistic Bolam approach in which medical or healthcare professionals were allowed to use their peers to make a determination in the court as whether there had been a breach of duty of care or not, to the more common patient-centric standard now, especially when it comes to areas of disclosure of what information, as we have seen in the Montgomery case. Courts also remain cautious in rejecting expert evidence, as we have talked about. But then, Bolitho tells us that medical opinion should be scrutinized, or expert opinion should be scrutinized to ensure logical consistency. Otherwise, the court is at liberty to reject it. Again, we have also noted the systemic pressures and reforms, particularly defensive medicine. A lot of people are pursuing medical negligence cases, even in our country, Ghana. And as awards are made in those cases, it's become a source of anxiety for the healthcare professionals or the medical community. And that triggers the phenomenon of defensive medicine, in which healthcare professionals become more concerned about how to avoid trouble rather than a genuine commitment to pursue the well-being, safety, and care of the patient. So there's issue, should we have a no-fault compensation? A no-fault compensation scheme simply means that should we evolve something like a fund, right, or a system, in some kind of like insurance, a general state-sponsored insurance or something like that, in which a person who has suffered injury in the course of medical treatment or procedure does not have to go through the burden of establishing fault in terms of breach of duty of care by the healthcare professional, and all that he or she will need to establish is what we call like that the injury that you are complaining of was caused by, let's say, a particular healthcare procedure or treatment, and then some compensation is provided from maybe either public funded or some state arrangement funded scheme. In which case, healthcare professionals and hospitals will not be so much alarmed about the risk of being exposed to hefty or heavy damages in medical negligence case. In which case, we'll move away from the fault-based negligence, which we have now. And of course, the fault-based is still the dominant in our jurisdiction and so many other jurisdictions. But in view of these practical difficulties, should we move away from that and embrace no fault compensation? I have a short article on that. I will make that available for you to read. Okay, so we will draw the curtain down here and continue the next class unless there are some questions to deal with. Okay, there being no hand up, have a good night.